welcome to the Deep Dive. Today we're looking into something happening in Congress, a bill that might sound a bit technical, but, well, it could actually change some important things. It's HR1526.
That's right. The No Rogue Rulings Act of 2025. NORRA for short.
NORRA. Okay. And we're working off the actual bill text from the government's publishing office here.
Yep, the official source. Our mission basically is to figure out what this bill is trying to do and, why it might matter, even if you're not deep into legal stuff.
Right. It's about how courts can issue orders, these things called injunctions. Is that the idea?
Exactly. Injunctions, court orders to stop something from happening.
Okay, so let's set the scene. How does it work now? My understanding is that currently just one federal judge, like at the district court level.
The entry point for federal cases.
Right.
Yeah.
That single judge can issue an order, an injunction, that stops something potentially across the entire country.
That's pretty much it. A single district court judge can issue an injunction that has a really broad impact, sometimes nationwide. Think about stopping a big government policy everywhere, all from one courtroom.
Wow. Okay, so that's the current situation. Now, what does this NORRA bill propose to change? Section 2A seems key.
It really is the core of it. Section 2A basically says, look, if a district court issues one of these injunctions, it should generally only apply to the specific people or groups involved in that lawsuit.
Just the parties in the case.
Yeah, the wording is applicable only to limit the actions of a party to the case and non-parties represented by such a party. So if you're not actually suing or being sued, the order typically wouldn't directly stop you.
Okay, so it narrows the blast radius, so to speak, of a single judge's order.
Exactly. The aim seems to be preventing one judge from setting policy for the whole country with an injunction, make the effect more localized to the actual dispute.
But there's always a but, isn't there? I saw an exception in Section 2B. What's that about?
Right, there's a specific carve-out. It kicks in when you have a certain kind of lawsuit. 2 or more states team up to sue the executive branch, so the president's administration.
Okay, multiple states suing the executive? Is there more to it?
Yes, and crucially, those states have to be from different federal circuits. The appeals courts are grouped into circuits covering different regions, so you need states from at least 2 different regions involved.
Got it. So, say, California and Texas suing together, that might trigger it. What happens then? No single judge.
Correct. In that specific situation, multiple states, different circuits, suing the executive branch, the case doesn't stay with the single district judge for the injunction decision. It gets handled by a special 3-judge panel instead.
A panel of 3 judges. How are they picked?
That's another interesting detail. The bill says they're chosen randomly, not appointed by the chief judge of the circuit, which is often how these panels are formed. Random selection.
Okay. Random panel. Do they have different powers? Can they issue those broader injunctions?
Yes, they can. This 3-judge panel is allowed to issue the kind of broader injunctions that Section 2A generally restricts for single judges.
But presumably with some conditions.
Definitely. They have to weigh specific things. Is it in the interest of justice? What's the risk of irreparable harm to people not directly in the lawsuit? And does the order uphold the constitutional separation of powers?
Okay, so they have the power, but with some guardrails they need to consider. What if someone doesn't like the panel's decision? Appeals. That's Section 2C.
Yep, Section 2C covers appeals. If the 3-judge panel issues or denies an injunction, the party that wants to appeal has a choice.
A choice. Where can they go?
They can either appeal to the regular Federal Circuit Court of Appeals for that region, or they can choose to appeal directly to the U.S. Supreme Court.
Straight to the top. Interesting. So let's pull back a bit. Why should someone, maybe just starting to pay attention to politics or law, care about these kinds of procedural changes?
Well, think about it. This could really shift how government policies are challenged in court if it's harder for one judge to issue a nationwide block.
Then maybe a new policy rolls out everywhere, except for the specific places where it's being challenged.
Potentially, yeah. It could lead to more patchwork results, at least initially. A policy might be active in one state but blocked in another while the cases proceed.
But the exception for the states means big multi-state challenges could still lead to broader halts just through this different 3-judge process.
Exactly. It suggests that for really major national issues that draw challenges from states across different regions, there's still a mechanism for a potentially wider court intervention, just not from that initial single judge.
So sort of rerouting the process for major challenges while maybe limiting the impact of smaller single district ones.
That seems to be the structure, yes. It might mean court battles play out differently, maybe with less immediate nationwide drama from a single ruling, unless it meets that specific multi-state threshold.
It definitely touches on that balance of power and how quickly and broadly court decisions can affect government actions.
Absolutely. It's about the mechanics of how legal challenges impact policy implementation across the country.
Okay, so let's recap quickly. This NORRA bill, HR1526, aims to generally limit federal district court injunctions just to the parties in the case.
Right, narrowing that scope.
But with a big exception. If multiple states from different circuits sue the executive branch, a special 3-judge panel takes over for injunctions.
And that panel can issue broader orders, considering things like justice and harm to non-parties.
And appeals from that panel can go either to the circuit court or straight to the Supreme Court.
That's the gist of it, a potential tweak to the judicial playbook.
So a final thought maybe for everyone listening. Changes like these, even if they sound like inside baseball for lawyers, can really shape how laws and government actions actually play out in your community and your life. Worth keeping an eye on.
Well said. Procedural changes can have real-world consequences.
Thanks for breaking that down with us. That's all for this deep dive.